Last but certainly not least is Govind Persad. He is an assistant professor at the University of Denver Sturm College of Law. He's published on COVID-19 policy in venues including the New England Journal of Medicine, JAMA, Science, The Lancet, the American Journal of Law and Medicine, and Health Affairs Forefront. He holds a JD and PhD from Stanford University.
Great, thanks everyone. I think maybe you were hoping you'd get through the day without hearing about any more COVID-19 topics. So hopefully it won't take too long to go through these. So I'll just start off with the second slide, walking through what we mean by flexible administration. So there are a variety of different COVID-19 interventions that we've probably, especially here and all of us listening, have heard about. So those that have what is often colloquially called full approval include the Pfizer and Moderna vaccines and the antiviral remdesivir. And full approval use on label at the bottom is it's always going to specify what populations and what uses the approval or authorization is for. That's true for those, also true for interventions like the Johnson & Johnson vaccine, newer antivirals like Paxlovid, and monoclonal antibodies. Then on the other side, we have interventions that have full approval, say for adults or for the primary vaccine series, but are provided under an EUA as boosters or to pediatric populations. And then last, we have two other categories. One is full approval off-label use. So you're using something that is fully approved in one population or for one use in another population or for a different use. So dexamethasone, a generic steroid that's used and recommended in hospitalized patients by the NIH, is actually used off-label. It doesn't have a formal EUA. Some have suggested pediatric vaccines for kids under 5, or say giving third or fourth or fifth boosters might be permitted off-label. And then there have been many drugs that have been repurposed for use off-label during the pandemic, including a variety of things that have been controversial. So hydroxychloroquine, for instance, was used initially off-label. And then last, I have a crossed off category, EUA off-label. There's no off-label use of something that's only emergency use authorized. That's just an unauthorized use. There's no off-label from an EUA. So why does all this matter? Why do these categories matter? One reason why has to do with statutes that protect against liability and provide compensation for injury. So if the use is authorized or if it's on label, you have protection from liability. And if you're injured, you have a program that provides compensation. And for liability, that includes even cases where you have a reasonable belief. Say someone lies and says it's their second dose when it's really their fifth booster. You're still protected under the PrEP Act. My co-authors and I think that for off-label uses, this is probably also protected because it is a COVID-19 countermeasure that's approved, even if not approved for that specific use. In contrast, unauthorized uses, say the EUA off-label that I crossed out, those would not be covered. And then similarly, they would also be a violation of FDA regulations, whereas off-label uses do not violate FDA regulations. However, off-label uses do seem to violate provider agreements the CDC requires vaccine providers to agree to administer vaccine in accordance with various requirements and recommendations. And if you violate these, it may result in both getting kicked out of the program and even potential criminal and civil penalties. So I'll walk through then in my next few slides examples where this potential enforcement action has or has not happened. So one case earlier on, while COVID-19 vaccines were still under EUA, was in Puerto Rico. A pharmacist provided vaccines to some kids 7 to 11 and ended up pleading guilty to federal charges. And the basis for the federal charges was in part that the vaccine batches were US government property, and because the population in which they were used wasn't authorized, it actually, in their view, they charged her with illegal conversion, something akin to stealing the vaccine or using it for a purpose that wasn't consistent with her ability to use that government property. In contrast, there have been other cases where, say, cities or hospital systems, including one very close to where I live in Denver, gave booster shots at times when those were not actually authorized even under an EUA, back when the vaccine was not yet fully approved. This is also technically conversion, but the DOJ did not show up and start serving orders on folks in San Francisco or the docs at UC Health for these EUA deviations. So there's been some variability in how active enforcement has been in this area in ways that I think are challenging to justify. There have also been cases where even after you have full approval, you might think, well, then you can just do off-label. Because of the provider agreements, the stance of the CDC has been, no, you can't do it even once you have full approval, because the provider agreements still say you have to provide them according to our guidance. San Francisco, interestingly, went ahead again and let people who got the Johnson & Johnson vaccine get a third shot, so a second booster, before that was recommended. And they said, well, we can do this because it has full approval. So it's just a standard off-label use. That's not actually so because of the provider agreements. But again, there was no action. No governmental representatives showed up in San Francisco to bother the SF Health Department, or certainly not bring charges against them if they had to agree to be kicked out of the program or pay a penalty. We've also seen situations where there's been off-label with no provider agreement. So a big discussion among parents who have been very desperate to get their kids vaccinated under 5, say kids with immunocompromise, have been actually flying to Germany, where that vaccine is available off-label and their provider agreements don't constrain in the same way. So there's no legal problem. So you have this, what some legal scholars have called circumvention tourism. And then you have in many states, I actually don't know if there's one in Iowa right now, but bills that protect doctors who prescribe off-label, say ivermectin or hydroxychloroquine, from legal action. While at the same time, weirdly, you have uncertainties about the new, more proven antivirals that are still only under EUA and not fully approved for anything. So when Vice President Harris got COVID, there was an active debate on Twitter about whether she should have been allowed to use Paxlovid, because there's a question about whether asymptomatic COVID is within the scope of the EUA. And there's been recent discussion about people who have more than 5-day long COVID symptoms rebound with Paxlovid. Can they take another 5-day course, or is that prohibited because it would be going beyond the scope of the EUA? And we think that the current regulatory environment creates a lot of challenges. So there are incentives, I think that we've all seen, to lie or circumvent to get vaccines or get boosters or antivirals. This degrades data quality, causes inequities. So the Germany case is an obvious example. Hampers follow-up. So if I got my 5th booster by lying and I get sick, am I going to want to explain that's why I have these side effects? Inconsistency. Off-label uses are quite common elsewhere in pediatrics, yet you have this prohibition on under 5 vaccines. Weirdly, you have actually more uncertainty about access to Paxlovid than totally unproven drugs. So say Vice President Harris were not an evidence-based person, she could go out there and find a doc who would prescribe her ivermectin for her COVID. And there would be no regulatory question about whether the doctor could do that. There might be a malpractice question, but there's no question about FDA action there. So what do paths forward look like here? I think some of the paths would include amending some of the EUAs, allowing enforcement discretion more explicitly. So saying we'll take action with some of these uses, but not others. Greater clarity on liability and compensation, and then having more clinical trials to develop more information about, say, some of these uses that are currently off-label or expanded access programs. And this is all based on, you can read for free on Health Affairs, work with Patty Zettler, who was supposed to be here, unfortunately couldn't make it, and Holly Lynch at Penn, where we lay out some of these arguments in more depth. Thank you so much.